There we go. All right, counsel, anytime you're ready.
May it please the court, I would like to reserve 5 minutes for rebuttal, if that could be
Sure.
appropriate.
Yep.
As the court's aware, the central point of this case is simply, does the assignment that my client holds, is it required to comply with Florida Statute 627-7152? This is not a novel issue that's been in front of the court, though it is a novel issue, and that I believe my client's assignment is the one that has actually operated outside of any sort of regulation. If you were to believe the appellee's position and the trial court's position, it's a one-part analysis. Was there post-loss benefits that were transferred? However, that's an incorrect analysis, and even the AJ court case in AJ versus First Community Insurance Company made that clear when it stated not every assignment triggers the requirements of section 627-7152. And my client's assignment, if you do the proper analysis, which they did in AJ, as well as in the Kidwell versus American Integrity Insurance Company out of this circuit, where it's a two-part analysis, should be found that my client need not comply. There's a two-part analysis. The first is, was there post-loss benefits being transferred? In this case, a chosen action or a right to recover was transferred, and those are post-loss benefit rights. And the second part is, specifically, is it to or from an individual who provides services to protect, repair, restore, replace property, or mitigate against further damages?
And Mr. Chavez, may I jump in right now?
Sure.
One of the things that I want you to address, which is kind of concerning me, is that I appreciate all the information that you provided, and you had it in very big bold, that this is not, it's not, it doesn't, that it should get it out of the statute. But how do you get around the fact that the claim and the complaint seeks, quote, and I'm pulling it up right now, payment in accordance with the existing direction of payment, and the relevant direction to pay and the record is to a roofing company, which is Nolan's Roofing, for repair of the roof. So under this framing, isn't it, you could argue that you all are simply a middleman for getting the policy benefits to the roofing company to get the roof repaired. And so this seems to somehow defeat your contention that this assignment is outside the scope of the statute. So that's my concern, and I want you to address it for me.
Sure, no problem at all. It is correct that there is part of the assignment says that the insured said, I want it to be paid to myself and to a direction to pay if it exists. So that is a little bit requires information that there was one being enforced at the time of payment. So that goes a little bit beyond that. But I think there's a proper analogy in that if I had a sibling who had a loss and they went and they repaired their property, and then an insurer said, we're not paying you a dime, or we're paying you $100, they can transfer that right for me to recover, to save them the time, expense, the harassment, the potential financial liability. And I could recover that for them. Now, the service that I provide is one of collection of something that should have paid under a breach of contract. And the service they're providing is simply to transfer it to me. Neither of us, as in AJ, where they talked about, I will do maintenance, are present there. And simply because a payment may be made in some accordance, whether it's to the insured solely or to the insured and the contractor, doesn't mean that those funds will be used for those. They can be used to pay down a mortgage. They can be used to go on vacation. They could be used, in theory, for subsequent remedial measures if they haven't been performed, or they could be just reimbursement for repairs that were already created. And if the repairs are already created, then my actions are doing nothing to actually allow repairs that already occurred. Just like the damages already occurred, we're simply seeking financial payment.
No, and And that may be well and good, but under the frame of this particular facts of this case, with that language in the complaint, if that language was not in the complaint, I think that argument, you know, you have a basis to proceed with that argument. When you have language in the complaint that basically says, and I'm pulling it up, I had it and then I just lost it right now, but the payment in accordance with the existing direction of the payment, and then the relevant direction of pay in the record is the roofing company. That's what troubles me. I appreciate your saying that if somebody, you know, for the generalized thing, but this seems to be in the complaint. How do you get around this?
Well, first and foremost, I would say that my client doesn't actually perform a repair service. Their services have nothing to do, like in Kidwell, where they went to the property, they did services at the property, and their services were directed to the property itself. Our services are directed to the homeowner in order to save time and expense. And even if our payment may have other individuals on there, which may or may not be used for repair, it still doesn't say that we are providing services to protect or repair. Our services have never been there. Our services only really kick in at the point of filing suit. So although there may ultimately be a payment that goes out to a third party, then that is fine. Now, I also believe in the complaint, if I can pull it up, the first sentence also says to pay HICA. So, and for clarity of the record, holding insurance companies accountable, it's just easier to call it HICA, I believe. So I didn't want to get too far out on that.
No, I appreciate it. So if I may, so where is the line then? Would a general contractor be covered under your scenario?
Well, I think that who the individual is less material than what was being exchanged. If their services are specifically, I am here to recover money so that I can go and repair your property, you're squarely in the statute. If I'm operating as an individual that simply is trying to protect you from financial liability and pain and other items which are clearly laid out in the insured acknowledgement form, I don't believe you're doing those things. Because like I said, ultimately the money may get paid and they're just selling the home. They're not using it for repair, or they're going to use it to pay down their mortgage. Or if there's no mortgage on it, maybe they just take it and say, I'll take the home as it is and move on. The basis for damages can be that there were damages under a policy, but it doesn't mean that those monies are inherently intertwined in actual repair. I didn't want, is there more, or can I?
No, you answered my question. Thank you, sir.
No problem at all. Thank you very
So
much.
I've got a question now. In the briefing, we've been strongly urged to consider the legislative intent of this particular statute, irrespective of how it might actually have been worded. Is that appropriate for us to do?
Well, I don't believe so, Your Honor. I think this is unambiguous. I don't think either party actually argued that it was ambiguous in seeking some sort of legislative review. Even if the court were to review that, I believe that all things still hold up. We're not a contractor. If you read the legislative intent, the legislative's intent is we're trying to make sure that contractors don't steal someone's claim and then charge exorbitant amounts. My client isn't doing that. My client is not a contractor, A. And then there would also have to be findings that somehow my client is blowing up bills or trying to create extra areas of damage, which were the true intent. I know there's the statement of, oh, well, we want to make sure insureds know what they're doing. I can submit to you that Mr. Dickinson has not come forward to complain and understood exactly what he was doing. He wanted someone to help him recover money. Is there a follow-up to that, sir?
Not for me, no.
Okay, I just wanted to double check. Thank you so much. I would like to also clarify that our assignment of benefits is not an assignment agreement. And I think that once you start looking at it as two different things, an assignment agreement under the statute as well as an assignment of benefits, inherently, it's easier to see how they are different, since it is very delineated. And I would like to also, if we're talking legislative intent, there was a subsequent modification to this, and it was subsequent to the creation of the assignment, to where the legislature did say, well, we want to add more things in there. Now, they all still connected to the property, saying an inspection or something like that, that involved a service at the property by that individual. But if the legislature knows that there's ability to make it bigger, and they have even shown the ability to do that and the knowledge to do that, then I think it's clear that this was the scope that they originally wanted and that would apply to this assignment. And if they wished it to be all assignments related to post-loss benefits and a property insurance policy, then it would have simply put a period after that exact statement, that this is for post-loss benefits and insurance or commercial policy, period. But they went and chose and made it more narrowed. And if it's not this assignment, which clearly has no services being provided at the property or directed to the property, and merely services from themselves to the insured being exchanged, then what assignment could ever be not subject to this statute?
Let me ask you this. Let me ask you this. Although this agreement is described as an assignment of benefits, isn't it really assignment of a cause of action for alleged breach of the insurance contract?
Well, and that's what went into what I was
I mean, is it contemplated that you would file a claim for payment from the insurer? It doesn't seem so. It seems it seems to say it's for the purposes of litigation.
Yeah, it's, as I was saying before, it's a transfer of a chosen action or right to recover under a policy so that we can pursue
But the
whatever
chosen
recovery
action is a right to, the chosen action is a right to sue for the recovery under the policy. It's not a right to make a claim to the insurance company for payment of a benefit under the policy.
Correct. And that's what we're here today, as we've clearly instigated litigation in order to recover those payments.
Right. And did your client submit a claim to the insurance company before filing the lawsuit to pay?
Not separately and distinct from Mr. Dickinson. Mr. Dickinson filed a suit, was not fully paid the benefits that were owed, transferred it to my client, and they filed suit.
Right. So this is not the scenario where a contractor or repair person comes to your client and says, hey, I'll do the repair work, assign me your benefits under the insurance contract, correct?
Yes, this was an assignment to my client in order to recover.
Of a cause of action that was at that point in litigation.
It was on its way to litigation. My client filed
Right.
suit.
Right, but did not file a claim to the insurance company. Hey, here's a bill, pay me.
No, sir.
And of course, you've read the briefs of your opponent in this case. It says that's why you haven't complied with the statute, because that's what the statute was intended to cover.
Yeah, I believe it was intended to cover contractors or other agents or remediation companies or somebody who is actually trying to trade their services for the right to recover from an insurance company, and those services being the ones to directly affect the property itself in putting some fans in or putting hammer to nail or anything like that. And that's often was done at the initiation, sometimes before the claim was even initiated. Those were transferred, whereas this is subsequent when there's already a dispute. And at this point, push comes to shove, they've got to either file suit or not. And they chose somebody else to help save them from those actions.
Did the work for which this claim was made, that work was performed before this assignment, I'm obviously correct?
In this circumstance, I guess the definition is what is work.
I mean, you know, the repair, whatever, what for the work for which the claim for benefits is made.
In this circumstance, I do not believe the full repairs were made prior to transfer because they did not have the money at that time. I do know that subsequent to litigation, independently from my client, the homeowner did pay out of pocket in order to make the repairs, and monies will be obviously
Right.
sought to recover that, but he did that without us recovering those monies for that reason.
At this point, you're down to your 5 minutes.
Thank you. I will withhold unless there's another question.
Okay, great. Thank you. Mr. Carter, you're up.
Good morning, may it please the court. Ben Carter on behalf of the FLE. I want to start with a quote from the 3rd District that this court has also adopted, and that is, if it looks like a duck and it quacks like a duck, then it is a duck. This simple
Well, you know,
reasoning.
I question that, Mr. Carter, whether this actually looks like the duck or quacks like the duck. You know, I mean, let me pose a hypothetical to you. Say I'm in debt to someone, and I owe them money, and I don't have it, but I have some things I can give them. I said, look, you can have my car. It's worth a couple grand. You can have whatever. And I have this claim against an insurance company. Let me assign that to you too for some value. Would that assignment qualify as you know, be included under this statute?
I think we would need to look at what you are receiving in return for the assignment. And in this case, we need to look at the purposes of the service that HICA is providing. And I think really we can be guided here by this court's previous opinion in the Kidwell Group versus American Integrity case, where Air Quality, rather, which was the DBA for Kidwell, was not itself providing any services to repair, protect, or restore the property. But this court said the services were basically in furtherance of the repairs. They were part of the homeowner's effort to remediate damage to property. And therefore, that triggered the application of the statute. I think here there's not a material difference when we consider the facts in the record between the services that Air Quality was providing in the Kidwell Group case and the services that HICA is providing to the insured in this case. They've agreed to file a lawsuit on behalf of the insured to recover benefits under the policy that are going to be used pursuant to a direction to pay. That is to a roofer who has prepared an estimate and submitted it to the insurance company with a contract to repair the roof. And I want to point out some key facts in the record that sort of demonstrate what these services are that HICA is providing. So this is the insured acknowledgement form and the assignment of benefits. Both documents, as we've said, claim that HICA is not providing services to protect, repair, restore, or replace property. But the assignment itself states that any payments on the claim shall be made in accordance with any direction to pay relevant to the claim. It also states, I, being the insured, am also aware that there may be a payment made from the person, company, or entity that presented, discussed, offered, or suggested the use of this agreement directly to HICA. Then if we go to the insured acknowledgement form, the insured states he is assigning his claim to HICA in return for HICA stepping into the insured shoes and risking its own time, money, and efforts to, quote, hold my insurance company accountable for their obligations under the policy of insurance, and also ensure that the direction to pay that I signed with a separate company is honored. And one other point from the assignment that I want to make that came up before, this wasn't merely an assignment of the right to sue. This was, from the assignment, a complete assignment of the claim. The insured stated, I hereby irrevocably assign and transfer any and all rights, benefits, and causes of action to Holding Insurance Companies Accountable, LLC, relative to the below referenced insurance claim, with the exception of additional living expenses or contents claims made. So this wasn't merely assigning the right to sue. This was assigning the entire claim to HICA, and the purpose of the assignment was to secure funds from American Integrity's policy to effectuate repairs of the property. So therefore, it was part of the insured's effort to remediate property damage, which implicates the statute's definition of assignment agreement. So in short, the statute applies to assignments of post-loss benefits under residential property insurance policies that are to or from a person providing services to protect, repair, restore, or replace property, or to mitigate against further damage to property. And this statute was enacted in 2019 by the legislature to provide some basic protections to policyholders when they were assigning benefits under their policies, and also to limit abuse of assignments of benefits. Subsection 2 of the statute sets some requirements for the form and the content of the assignments and provides that any assignment that does not comply is invalid and unenforceable. And the issue here is not whether this assignment complies. HICA concedes that its assignment from American Integrities Insured does not comply with the statute. Instead, HICA claims that because the sole purpose of its assignment is to file a lawsuit against American Integrity, its assignment is not then to a person providing services to protect, repair, restore, etc. So even though the undisputed purpose of this lawsuit is to collect benefits under the policy, to pay for roof repairs, HICA claims that its assignment does not meet the definition of assignment agreement and does not have to comply with the statute.
And Mr. Carter, you seem to be arguing that at least some of the purpose was to repair, which would put it under the statute. Is that what I'm hearing you?
That's correct, Your Honor. It's part of the homeowner's effort to remediate property damage, which is the language this court used in the Kidwell Group case.
But you know, whatever language we may have used, that is not the language of the statute. And we are in an era of textualism, are we not? And the statute says an assignment to or from a person providing services, including to repair, to protect, repair, restore, or replace the property, or to mitigate against further damage of the property. That's the language of the statute.
That's correct.
Yeah.
That is the language of the statute. And it's our position that that language is simply not as narrow as HICA would read it. It's, the plain language of the statute is that the person is providing services to repair, protect, replace, etc. The statute doesn't define what services it means. HICA would read it as it's only the enumerated services that would apply. However, this argument is contrary to that plain language, saying what the statute says, which is a person providing services to protect, repair, restore, etc., is not the same as saying to or from a person providing protection, repair, restoration, replacement, or mitigation services, which is how HICA reads the statute. And I think the way this...
What if the scenario was such as I posited before? Say that the insured came out of pocket and paid the roofer or whoever, and the insurance company doesn't want to pay the claim. Could they have assigned that claim to HICA and that would be outside the statute?
I don't believe so, Your Honor, because I believe it would still be in furtherance of the insured's effort to remediate property damage.
Insurance wouldn't it be arguably in furtherance of the insured's effort to recover money that he considers he's entitled to under a contract, i.e. a cause of action? I have a problem reading this provision so broadly that if it has anything to do with damages to an insured's home and trying to recover money for that somehow the assignment of that cause of action is going to be invalid under this contract unless you've given a copy to the insurer and all of this ahead of time. I mean, that language just isn't that broad.
Well, Your Honor, I believe in the Kidwell case, the court made it clear that it's the purpose of the services that are being provided. So I don't dispute that there would be scenarios where the statute may not apply.
Was the Kidwell case in the Florida Supreme Court?
It was not. It's from this court, Your Honor.
Okay.
So, but just to stay on that point a little bit, I do think we have to consider, while the plain language of the statute is clear that it is services that are to facilitate, repairs of the property. That's what what triggers the application of the statute, we also need to consider the purpose of the statute, which was to provide protections from, or protections to policyholders when they're doing these assignments of benefits. The statute is not about,
The problem with that, though, Mr. Carter, is we could find that purpose, but we can't legislate to satisfy the purpose. The legislature has to do that. And it does that with the language in the statute.
correct, and the plain language of the statute, I believe, reflects that purpose. The purpose is to protect the policyholders. If the statute is not about HICA and it's not about the roofer. It's about providing protections to the policyholders. If the court were to accept HICA's argument, the insured is deprived of this bundle of protections that the legislature intended to provide. So simply by splitting up who is doing the work and who is collecting the money, HICA and the roofer have effectively circumvented the statute and nullified these protections that the legislature intended to provide the policyholders.
Now, that as you have described it, is that something that would require some sort of evidence and fact determination? You know, that their true purpose was to circumvent the statute?
I don't think so. It's not a fact that we're seeking to prove as part of our entitlement to relief. But I do believe
what your assumption is.
Correct. Well, it's the effect. It's not necessarily an assumption. It's the effect of what accepting this interpretation would be. If they split up the lawsuit to collect the benefits from who's actually performing the work, then there's no requirement that the insured be advised of all of the rights and obligations that 627-7152 requires be included in an assignment agreement. There's no indemnity protections for the insured that the legislature intended to provide. And there's no notice requirements to the insured and to the insurance company with regard to the assignment. And I think we have to also look at the facts in the record I discussed earlier about the true purpose of the assignment being to collect these benefits, showing that HICA and the roofer are working hand in hand, and that for this purpose, you've really got to treat them together.
So if I may,
that is a fact question, that they're working hand in hand.
It is a fact question, and I believe it's supported by the record. The assignment itself states that, and this is the language of the insured, I understand and agree, or pardon me, that's the wrong line. I am also aware that there may be a payment made from the person, company, or entity that presented, discussed, offered, or suggested the use of this assignment directly to HICA. The assignment and the acknowledgement form also make clear that the insured wants the direction to pay to be honored, and the only direction to pay in this case is the one from Nolan's Roofing for repairing the property's roof.
So Mr. Carter, let's just assume that that the complaint did not have that language.
The direction to pay.
Correct. If it was just simply, we have the assignment benefit to proceed, against, it's basically a breach of contract action, you would agree that, they don't have to comply with the requirements of the statute if you remove that from the complaint.
I would not agree, because it's not the complaint that determines whether they have to comply with the statute. It's the assignment agreement itself. And the assignment is still...
If the assignment does not have that language dealing with the roofing and did not have that specific language, direction to pay.
Correct.
If you remove that from that, wouldn't an argument could be made that, there's no need to comply with the statute because you don't have a specific direction to pay. If all that was removed from the facts of the case, and this is simply a hypothetical.
The argument certainly could be made, and I think if that were the case, we would have needed some additional discovery below in order to establish, okay, what exactly is this money going to be used for? What purpose did the insured assign their claim to HICA for? But in this case, with this record, we have the direction to pay language in the complaint, in the assignment, in the acknowledgement form, and we have the direction to pay itself from Nolan's Roofing showing that the money paid out on this claim is going to roof repairs. So once again, it's part of the effort to remediate damage to the insured's property, and the services that HICA is providing in filing a lawsuit to collect those benefits are part and parcel of the homeowner's effort. So there's just a couple more points I want to address that came up in the appellant's argument. First is that American Integrity's interpretation and the trial court's interpretation of the statute would basically extend it to all post-loss benefits, all assignments of post-loss benefits, and it would become a one-step analysis. That's simply not the case. First, we have subsection 11 of the statute that specifically excludes certain assignments of benefits that may otherwise be subject to the statute. And that includes assignments to subsequent purchasers of the property, and also powers of attorney to persons who are granted authority to act on the insured's behalf with regard to a claim. That indicates that this statute could reach, beyond repair professionals. If HICA's interpretation were correct, there would be no need for a blanket exclusion of these assignments, because they would never be subject to the statute unless the purchaser or holder of the assignment or power of attorney was in fact providing repair services. And second, the statute still would not apply if the assignment, or if the assignee rather, were not providing any services as part of the homeowner's effort to remediate property damage. We've alluded to some potential examples of that today. One I thought of was a homeowner who has a roommate who is not an insured, not an owner of the property, and there's a claim for some personal property damages, part of which belongs to the roommate. The homeowner would be able to assign a portion of the benefits under the policy to that person to cover their contents loss, and that is not, there's no service being provided to repair, replace, or restore property. So that is potentially an assignment that may be outside the purview of the statute. There were also some comments about the subsequent amendment to the statute, and essentially that we are inserting language into the list of services that are described in the amended version of 627-7152 and rendering that definition nonsensical. But I don't.
Because
Yes.
I know we have limited time. I want to follow up with one of Judge Northcutt's questions, because I want to be able to. I think based on what Judge Northcutt said, and I may be misinterpreting that, since the insured in this case made the claim before HICA got involved, an argument can be made that this is not one for repair of services. It's just simply getting benefits. Does that change this whole scenario here?
I don't think it does, because the statute doesn't deal with who made the claim, or when the claim was made, or when the assignment itself is made. The definition of assignment agreement under the statute deals with what was assigned, which is a claim for post-loss benefits. The language of the assignment here indicates that it was the entire claim, with the exception of living expenses and contents, that the insured assigned. And then the assignment has to be to a person, to or from a person providing services to repair, protect, so on. And the record in this case shows that HICA was providing a service. A service is, the plain meaning of service is doing something of value for a person, or using your time, effort, or skill, which is exactly what HICA was doing, filing a lawsuit in this case to recover benefits that were going to be used pursuant to the direction to pay to make repairs to the roof. This was part of an effort.
In other words, the legislature extinguished the homeowner's right to assign a cause of action.
That's not correct, Your Honor. Subsection 11 shows that there are assignments that are expressly accepted, and I believe we've discussed scenarios where other assignments where there's no services involved for protecting or repairing the property would not come under the purview of the statute. So if there's no other questions from the panel, I will briefly conclude. Simply stated, HICA's assignment is an assignment agreement under section 627-7152, regardless of HICA's attempt to disguise it as something else. Because HICA agreed to provide services to file a lawsuit for insurance benefits that would be used for roof repairs as part of the insured's effort to remediate damage to his property. To hold otherwise would permit HICA to circumvent the legislature's attempt to regulate post-loss assignments of benefits and leave the insured without the protections that the legislature intended to provide in these scenarios. Accordingly, American Integrity respectfully requests that the court affirm the order on appeal.
Thank you very much, Mr. Carter. Mr. Chavez, you are up with 5 minutes left.
Thank you. Just to briefly go at what was just stated 2 seconds ago, there's no evidence in the record that states that we were seeking recovery of monies that in fact would go to repairs. That's not supported in the record. The direction to pay, we also have briefed and argued that it was unauthenticated and not able to be used by the court in any opinion. But
Well, let's just assume, Mr. Schiff, let's just assume for argument's sake that it was properly in the record.
Understood. And I'm just going on, if I don't make my record, I'm not doing my client any service.
No, I appreciate that, but just for purposes of argument, because I really want to hear your position on this. Let's just assume that that was appropriate. It's in the record. You have that, the Nolan's, the amount, the estimate. You have all of that. And this is where the specific term of direction to pay, pursue, and then you have this Nolan's amount. That's in the record. That's in the complaint. If you remove all that, I think your argument could be well taken that it would be appropriate to get it out of the requirements of the statute. But because those are there, just I want to give you an opportunity to tell me why I'm seeing it that way.
Well, I don't believe that our services are in order to effectuate a repair. I think that ultimately whoever gets paid does not mean that repairs necessarily will be performed. And there's no record evidence of that. That simply my client's services do not change based upon what that money ultimately gets used for. My client is still here to provide financial protections and provide the freedom from headache, the things delineated in paragraph 8 and 9 of the complaint, as well as the assignment and insured acknowledgement form. None of those services change based upon who holds it, as well as the wherefore clause in the breach of contract does not even indicate that all the monies are going towards the direction to pay. So for all of those reasons, I don't believe our services are really one and the same as what the statute would cover. And I also want to address the Kidwell bring up again. In that, they'd even pled that their services were being provided to identify damage. And in order to further assess what was there in order for coverage under the policy, and they were seeking payment for their services from American Integrity, not for the failure to pay outside of what they did in furtherance of checking the property for damages and providing scopes of repair or presence of mold. And that's inherently different because my client is not charging any service done at the property to American Integrity. Instead, it is seeking recovery of what should have been paid pre-suit. And that is what the basis of the breach of contract. Walks like a duck, talks like a duck. If it's got feathers, it doesn't mean it's a duck. And this assignment may have feathers, but it's not walking like a duck or talking like one. It does something inherently different. And for the protections that American Integrity has just told the court that it feels the insured's not getting, what else is this other than protection for the insured based upon providing that statement from American Integrity coming after them if something were to go bad in the claim, and providing them the financial security and peace of mind that is present here in this assignment.
And if I may, Mr. Schatz, would the statute apply so long as any of the benefits are for repairs?
I do not believe so. I believe that
Why?
if you are seeking benefits, you're seeking recovery of money. We're not seeking American Integrity to put hammer to nail or to give us authority, us being holding insurance companies accountable, authority to do that. If we're seeking money, it's a breach of contract. We're just seeking money that should have been paid. And those monies can be ultimately used for repair or other, but that is not a service that would create a protection, repair, restore, or replace. It is one that is secretly mainly just financial compensation. If there's nothing else, I just believe that it should be well taken, and I appreciate the court's time today.
Thanks so much. Thank you both. In order to leave our virtual courtroom, you should click the button on your Zoom screen that says leave, and you'll go off into the ether.
Thank you, Your Honor. Have a good day.
Thank you, Mr.
Thank you all.
Right, and our next case is MHC Cortez Village versus Cortez Road Investments, etc.